Their Lordships.
Application in the appeal, Queen on the application of E and against the Governing Body of JFS and the Admissions Appeal Panel of JFS and others.
Yes, Miss Rose, this is your application.
Yes. My Lords, my Lady, I appear with Miss Mountfield for the respondent. Lord Panic and Mr Oldham appear for JFS, Ben Jaffe for the United Synagogue, and Mr Hart and Miss Lambert for the Legal Services Commission.
Thank you.
My Lords, my Lady, it's only a short walk across Parliament Square, but a giant leap for our judicial system. It's impossible not to have some mixed feelings today on this historic occasion. After more than 1,000 years, we have broken the direct line of descent that led from the Anglo-Saxon Witangmot to the Appellate Committee of the House of Lords. On the other hand, it's surely about time, more than 250 years after Montesquieu mistakenly attributed the remarkable freedom of the British people to the separation of powers, that we should finally achieve that separation.
Well, perhaps it's a mark of the seamless transfer that we're sitting this afternoon as three, following a hearing that was the very last hearing in the House of Lords on the same case.
Yes, my Lord, and indeed by coincidence, I have the privilege of being the last person to address the Appellate Committee and the first person to address this Supreme Court.
Well, that's a pleasure for everybody, I'm sure.
On behalf of the Bar, I would like to wish your Lordships and your Ladyship every happiness in your new home, and to express the confident wish that this Supreme Court will become, as the House of Lords always was, in the words of William Blackstone, one great court of appeal, which is the last resort in matters both of law and equity, and which will therefore take care to preserve a uniformity and equilibrium among all the inferior jurisdictions. A court composed of nobles advanced to that honour for their personal merit, who are formed by their education and bound upon their conscience and honour to be skilled in the laws of their country.
Thank you very much.
Can I now turn to the matter in hand, which is perhaps somewhat less elevated than the occasion on which we sit, but nevertheless of very great importance to those involved. I hope that your Lordships and your Ladyship have had an opportunity to see the various skeleton arguments.
Yes, they've come in bits and pieces, I'm afraid, but we have an application by you which has been properly bound up now.
Yes.
And we have submissions for JFS. We've also got United Synagogue's submissions, and I think we've got something from you, Mr. Jaffe. Yeah, so I think we've got papers from everybody.
Yes, and there should also be a small evidence bundle.
Yes.
Yes,
like that.
somewhere. Yes.
And a slim bundle of authorities.
Yes. Yes, we have. Thank you.
If I can invite the court to turn up our application, you will see from it that, from the first paragraph, that we are applying for an order that whatever the outcome of the forthcoming appeal to the Supreme Court, the appellants shall not be entitled to seek the payment of any costs from the Legal Services Commission or from the respondent. And we say, for the avoidance of doubt, that that is to apply both to costs in the Court of Appeal and to the costs of this appeal.
Would it be jumping too fast to suggest that the application divides itself into three chapters? One is looking back at the costs in the Court of Appeal, and that may raise distinct issues as whether it's right for a protective costs order to look backwards in that respect. The second, which is partly related to that, but there's a bit of forward in it too, and that's the United Synagogue's position, which, as presented to us, doesn't seem to raise an issue of general public importance. It's important to them, but it's a specific issue relating to them, and your order as framed would certainly cover that position, because it's all embracing. And the third is the protective costs point, looking to the future, that is the appeal before the Supreme Court.
Yes.
and the question is whether it's right that an order should be made protecting you against them.
Yes.
So there are these three things, and as I understand the way this is framed, it's covering all three.
Yes, it is covering all three months.
Thank you.
As the court will know, we are making this application in response to a letter that we received from the Legal Services Commission on the 18th of September, in which the LSC informed us that they were minded to refuse our application for funding in the Supreme Court unless the LSC was protected against costs. If I can just invite the court to turn that up, it's in the evidence bundle at page 45. So this is a letter to my solicitors, Bindmans, from the Legal Services Commission. I refer to your letter dated 15th September, our telephone conversation of yesterday evening, and your email of today's date. For the avoidance of doubt, it is correct to say that I am minded to refuse your application for funding E as a respondent in the Supreme Court, unless the other side is prepared to, 1, allow the cost order made in the Court of Appeal to stand in any event, and 2, agree an undertaking that there will be no costs order in the Supreme Court, with both sides bearing their own costs. If that is not acceptable, we would expect an application to be made to the court to seek an order along those lines, failing which funding would not be provided. So it's in the light of that ultimatum that we find ourselves here today.
But that is not, of course, the application that you are making.
No, it's not.
No.
Because we are not making the application that there should be no costs order in the Supreme Court with both sides bearing their own costs. I'm going to return to that point in some detail, but I don't know whether your Lordship's had an opportunity to read the witness statement of Mr. Halford. There are very serious implications for access to justice and for the effectiveness with which legal aid firms are able to operate if such orders were to be made at the behest of the Legal Services Commission.
Does that mean there's really a fourth issue? I suggest
Yes,
there were three,
is.
so it is
yes,
a fourth
there is
issue.
That is a fourth issue.
Right.
But I'm sorry, can I just go? I mean, you're not seeking an order in the terms of paragraph 1 of that letter either, are you?
Yes, we are.
That the Court of Appeal order should stand in any event.
I think that was the intention, but I take the point, my lord, that
I mean, under that order, even if JFS win the appeal, they are still paying your costs. I hadn't appreciated you were going that far.
No, I don't think I am going that far. It may be that the Legal Services Commission would want to explain the basis for that.
Well, I thought that was the first issue, as to whether you were going that
far. Well, we are making the submission that the Legal Services Commission should not be liable to pay the costs of the school in the Court of Appeal in any event. But we are not making the application that the school should be liable to pay the costs of the Legal Services Commission in any event in the Court of Appeal. But it may be that that's an application that the Legal Services Commission would want to develop. So the letter goes on, regrettably, with somewhat of a lack of specificity in terms of particular paragraphs in the funding code that are relied upon. And I should say that we have had considerable difficulty in reconciling the reasoning in this letter with the funding code. But the letter goes on to set out factors which are said to have been relevant to the decision. They say, our reasoning behind this decision stems from the funding code, which in the circumstances of this case allows the refusal of funding unless the likely costs are proportionate to the likely benefits of proceedings having regard to the prospects of success and all other circumstances. Well, we don't accept that that is actually what the funding code says, but it may be that that's a matter that the Legal Services Commission would wish to make submissions on. But they then make the point, your client has effectively succeeded in the primary purpose of the litigation. Then the second point that they make relates to the extent of the exposure of the fund to the costs of the other parties. Then they say the real interest in overturning this case lies with the appellants and a number of the intervening parties, including the government. If they wish the issues to be resolved, it's not unreasonable to expect them to pay to do so. And that is a line of reasoning that we would respectfully endorse. And it's certainly a line of reasoning that has been adopted in other cases. there have been cases in which, for example, the Court of Appeal or a divisional court has granted permission to appeal to the House of Lords on the basis that the appealing party is pursuing a point of broader public interest and as a public authority ought to pay the costs of both sides in any event.
Well, it's quite familiar territory in cases where the LSC is not involved.
Yes.
I mean, the distinct issue here is whether
how
it's
that
a different
marries-
position
yes,
where the LSC are
with the
involved,
statutory
particularly
claim.
where they've supported appeals
Yes.
in the Court of Appeal.
Yes. My Lord, I ought to make it clear that I am not, by these submissions, seeking to suggest that it is our position that the threat by the Legal Services Commission to withdraw funding in the event that a protective cost order is made would be lawful. It is in fact our position that any withdrawal of funding from E at this late stage, less than 4 weeks before the hearing, in a situation in which he was successful in the Court of Appeal, in which this appeal will go ahead in any event, whether he is here to make the argument or not, and in which, if there is no protective costs order and no funding, he will be inescapably at risk of personal liability for costs. It is our position that to withdraw funding in those circumstances would be unlawful. And if your Lordships and your Ladyship were to refuse the protective cost order that we make today, perhaps at the point of a bayonet, and we then had our funding withdrawn, we would be making an urgent application for judicial review of that decision by the Legal Services Commission.
Do we have to go through that loop, or is it, I think Lord Panic is suggesting we might be able to just simply exercise
yes.
powers under the Act.
Well, my Lords, we certainly wouldn't dissent from the course that Lord Panic is suggesting. There are issues of very great concern.
Before you move on from paragraph 3 of the letter,
yes,
it mentions a number of the intervening parties, including the government.
Yes.
Now, what is the position on interventions in the substantive case?
I am not clear exactly how many applications to intervene have been allowed so far. They have been made.
We have not seen any applications. I mean, the registrar may have seen some applications, but we have not seen any applications.
To our knowledge, applications to intervene have been made by the Board of Deputies, the Secretary of State, and the Legal Services Commission. The Equality and Human Rights Commission.
What about the Synagogue?
Yes, and the Synagogue. Of course, the Synagogue are also an appellant, but they have also applied to intervene.
Yes, they intervened below, is that right?
Yes, they're now an appellant against the costs order, but also applying to intervene.
Right, yes.
And there are applications by the Secretary of State, the Equality and Human Rights Commission, and the Board of Deputies to intervene.
But as Lady Hale says, we've not actually been asked to consider any of these applications.
I suppose that's not surprising, given that there was an interregnum.
Well, I would hope that we would have been told about it if they were in hand. I'm not sure they've even reached the registrar.
I have seen them, so I believe they have been lodged. They've certainly been served on us.
Well, perhaps I can just say, the sooner they're in, the
Yes,
better.
I believe they were
If anybody here
lodged
is
in
in
the
control
middle
of events, the sooner they come in, the better,
Yes,
because
absolutely.
we really need to know. I think everybody needs to know.
Everybody needs to know, and in particular, who is going to make oral submissions and how we divide up the available time. But just on paragraph 3, the example I was going to give was the BAE case, the Corner House case. That's an example of a case in which, because of the public interest, the divisional court granted permission to appeal to the House of Lords on the basis that the government would pay the cost in any event. The final point that's made here is the number of people who are likely to benefit is relatively small. Now, I believe this is a matter that Lord Panic is intending to develop, but we don't accept that that is an adequate characterisation of the public interest in this case.
Sorry, I'm pulling a face.
Yes, but my lady...
And you will understand why I'm pulling a face.
There may be little more that I need to say than that. It speaks for itself, but we do submit that is not adequate.
This is in the interests of children generally,
Yes.
whose families wish them to attend faith schools. It's not just a Jewish issue.
No.
Entirely. I mean, it is on the legislation, but one could see other issues arising under other
and
legislation.
Indeed, even in relation to the Jewish issue, it's already a matter that, of course, has provoked intense debate in the Jewish community and which has led to pretty much every Jewish state school amending its entry criteria. So to describe this as a matter of limited public interest, what we would respectfully submit is hopelessly inadequate.
And Ms Rose, I mean, on factor one of that letter, that E has effectively succeeded in his primary purpose.
Yes.
I mean, that's only because we lifted the stay at the end of July.
That's right.
And it's slightly
ironic
and would be rather bizarre if our doing that actually created substantively a very different picture as to the entitlement to withhold legal aid at this stage.
I respectfully agree, my Lord. And even that, we suggest, is somewhat simplistic. It's very well established in the context of discrimination cases that the vindication of the right to equal treatment is in itself an interest that individuals have. And so it's not simply a question of the material benefit, it's the vindication of rights. There is another point to be made as well, two more points to be made. The first is that the boy has an outstanding claim for damages in the county court, a private law claim for damages for discrimination.
Can you explain to me, Ms Rose?
Yes.
It may be a distraction from today's proceedings, but it's a question that I've had in my mind since the last occasion that we had the pleasure of meeting. Why was this started as a judicial review case at all? Because you can get the remedy that you want out of straightforward county court proceedings.
The answer is that the case that your ladyship now sees is the tip of a case that was originally framed on a number of other grounds, some of which were pure public law grounds.
I see.
For example, there were issues about fettering of discretion, procedural unfairness in the appeal panel. There were also allegations, which of course were successful, of a breach of Section 71, the public sector duty, which is only challengeable by judicial review. So this was a case where there were mixed private law and public law causes of action. So what we did is what has been done in many cases, is to commence proceedings both in the county court and in the administrative court, and to stay the county court action and proceed with the judicial review in order to get a definitive position on all issues in one hearing.
So is the county court case going to ride on the back of decisions in this case?
Yes, my Lord. So, of course, the decision of this court will determine whether the damages claim can proceed in the county court. So we say that that is not correct. Of course, it's technically the case that the claimant in the county court is the boy and not the father, but we would submit that that, in these circumstances, is a matter of form and not substance. There is also, a point I should also make, is that there were, of course, two claims for judicial review. The first was the claim against the school relating to the refusal of the child, but the second was a completely freestanding judicial review of the decision of the school's adjudicator upholding the school's entry criteria. Because under the legislation, a parent who lives in the local area and who has a child of primary school age has a statutory right to challenge the entry criteria of a local state school to the school's adjudicator. And that right was exercised by E, and the adjudicator dismissed, with one exception, which is of some significance but doesn't need to trouble us today, dismissed the bulk of the complaint. And that's why the school's adjudicator was also a defendant to the judicial review. And that, of course, was also a claim that could only be brought by judicial review. But again, as regards that claim, the outcome of that judicial review claim, even though the adjudicator has not appealed to this court, the question whether the adjudicator's decision that the school's criteria were not discriminatory, whether that can stand or not, will, of course, also hinge on the outcome of this appeal, in practical terms. So we submit that the first paragraph is not correct, and the third and the fourth paragraphs, again, we say not. The fourth paragraph is not correct. So when we received that letter, we invited the other parties to agree to the terms, or at least to agree not to seek their costs against E or the Legal Services Commission, but they refused to do so. And their letters, first there's a letter at page 47 from Stone King Sewell on behalf of the school. And then there is a letter at page 53, which is from Farrer & Co., which is the response on behalf of the United Synagogue. I should also show the court our letter of the 22nd of September, which starts at page 49, in which we protested at the stance that the Legal Services Commission was taking. And in particular, we focused on their proposal that the right approach in this court was that each side should bear their own costs. And we made the point that under the Legal Services Commission's high-cost case regime, the hourly rates that are paid to solicitors and counsel and the number of hours which are permissible and which are allowed to be paid are very strictly limited. So in relation to the Court of Appeal, where we operated on risk rates, the effective hourly rate of my instructing solicitor on the number of hours work that he actually did was about £53 an hour on the risk rates. Now, it may be that the rates that would be allowable in the Supreme Court would be somewhat higher because they would not be risk rates but prescribed rates, but they would still be very significantly below the level which is profitable or sustainable for any legal practice in London. And the point that is made by Bindmans here is that firms like Bindmans, which do a large proportion of legal aid work, are only able to sustain that practice on the basis that they have to take the very low rates if they lose a case, but that if they win, they can recover inter partes costs on a reasonable basis. And of course, the other side always has the protection that the cost must be reasonable and can be assessed if not agreed. And if they are in a situation where they can only recover the Legal Service Commission level of costs, even if they win the case, it will simply be impossible for firms like Bindmans to continue to do the work that they do, with very serious implications for access to justice. And I'm going to return to this a little later.
Well, can I make sure? I think I do understand this. I mean,
Yes.
by reference to really paragraphs 23, 4, 5 of Mr. Reddin's statement in the purple bundle for the LSC. I mean, there are three rates. There's risk rate, which is very low.
Yes.
Then there's prescribed rates.
Yes.
And apparently when, as here, you're defending
Yes.
in the Supreme Court in a second tier, on a second tier appeal to try and
Yes.
hold a successful judgment below,
Yes.
you get those. Is that
Yes.
the same as authorised legal aid costs, prescribed rates?
My Lord, I don't know the answer to that. But
I see.
But
And then the third one is the
inter partes.
inter partes.
Yes.
I ask about the authorised because paragraph 24,
Which witness statement are you looking at, my Lord?
so Mr. Reddin,
We have two witness statements from Mr. Reddin. Is
Right.
this the one in these proceedings?
Well, it's one that's in this,
That-
this file here.
I have all the material in this one.
oh dear,
I wasn't able to find the statement Lord Brown's referring to in this similar
No.
file, I must say.
Is it not the one at page 55?
Oh,
wait a minute. It may well be, it may well be.
I think it may be. Sorry, yes, I think you may be right.
Absolutely right, no, absolutely
Awfully
right.
like it.
Absolutely right.
Yes, sorry, I
Absolutely
didn't
right.
look far enough.
But it's paragraph 24 of
Yes.
that, and there, if you see line 4,
Yes,
rule of
usually
thumb.
2 to 3 times greater than authorised legal aid cost, yes.
No, but is that, so authorised legal aid costs are the same as line 2 of that page, prescribed rates, are they?
Yes, my Lord.
They
Yes,
are
my-
the same.
And the same point was made by Mr. Reddin, in fact, in a witness statement in another set of proceedings, which is also in this bundle. It's at page 11 of the bundle, where he explains it. If your Lordship goes to page 13, paragraph 5,
Yeah.
so he says, in all high-cost civil cases, the first £25,000, including the first £5,000 of counsel's fees, are paid at the usual current rates as set out in the Legal Aid and Civil Proceedings Remuneration Regulations, typically £75 an hour, £79.50 for London solicitors, plus an appropriate enhancement, and barristers typically £150 for a senior junior, £250 for leading counsel. At the point costs exceed £25,000, all further funding is subject to a contract based on fully costed and agreed case plan and lower rates of remuneration. These thresholds are set at the point at which solicitor and barrister are expected to accept part of the financial risk of pursuing a case in cases where inter partes costs are likely to be recoverable. They allow the solicitor and barrister to be paid at generally applicable rates whilst assessing the risk of the case. Once the threshold is reached and it's decided to take the case to a conclusion, they're paid at the lower public contract rates, currently £70 an hour for a solicitor, £90 an hour for a senior, including leading counsel, £50 an hour for junior counsel. And then at the end of the case, the solicitor can opt to take costs from the Commission or costs from the other side, but not both, and that's another point I shall be returning to, unless certain conditions apply. Hourly rates, whether contract rates or risk rates, are significantly less than inter partes rates, so that both levels of legal aid rates are significantly below the inter partes rates, which can range from £150 to £300 an hour for solicitors, depending on the nature of the work and the location of the solicitor's office. It follows from the above that for many firms which are reliant on legal aid, the recovery of costs on an inter partes basis is critical to their profitability. This is particularly true of firms which split their work between certified cases and legal help, which only pays approximately £50 an hour. And we respectfully agree with that analysis. And our submission is that if we are not permitted to recover our costs on an inter partes basis if we succeed, and if that were to become a precedent for the approach to be taken in public interest cases before this court, there would very soon be a complete cessation of firms that were able to undertake legal aid work. Simply isn't viable.
Yeah. Yep.
And indeed, the position is worse than that because of the point made at paragraph 7, that the solicitor can opt to take costs from the Commission or costs from the other side, but not both. You have to make an election at the end of the case, either to take inter partes costs from the other side or to take costs from the Commission at the Commission's prescribed rates. Now, just to see how that would work in this case, let's say that we were to succeed in the Supreme Court. We have a costs order in our favour already in the Court of Appeal, and we could opt to take that and to take inter partes costs in the Court of Appeal. But if we were to take that, we would not be paid at all for the work that we had done in the Supreme Court, if this court had held that each side should bear their own costs in the Supreme Court. Because what we could not do is to say we'll take the inter partes costs of the Court of Appeal, but the Legal Service Commission's costs in the Supreme Court. So we would be in an impossible position where either we recover only the risk rates in the Court of Appeal and the prescribed rates in the Supreme Court, or we recover the inter partes costs in the Court of Appeal and nothing at all in the Supreme Court.
Yes.
Just going back to the letter that we sent to the Legal Services Commission, we, at pages 50 and 51, turned to the predicament that the Legal Services Commission's stance would place E in. And this is the point that I've already made to the court, that he did not initiate this appeal and he cannot get out of it now. The appeal is proceeding, whether he actively participates or not. If no protective costs order is made and the Legal Services Commission withdraws funding, he will be at risk of paying the other side's costs in the Supreme Court at the same moment at which his legal support is wholly withdrawn.
It's really a consequence of funding him through the Court of Appeal, isn't it? I mean, obviously, if you go to the Court of Appeal, you're at risk of a further appeal, provided leave is given. Yes. If it's a case of general public importance, it's quite likely that leave would be given to the unsuccessful party to try again. But it's all part of the original funding exercise, one would have thought. And
and we've made the submission that there are serious Article 6 implications here, because if a solicitor is advising a person who is eligible for legal aid and says to them at the outset, well, I have to warn you that if you win your case, and this of course needn't be at the level of the Supreme Court, it could be at the level of the Court of Appeal, if you win your case, there is a risk that the Legal Services Commission may then decide, if the other side get permission to appeal, that they will not fund the appeal. And in those circumstances, you will be at risk of the other side's costs in the Court of Appeal, even if you play no further part in the action. We submit that is wholly unsupportable and must be inconsistent with the legitimate expectation of a person who is funded by the Legal Services Commission, that they will not be left at risk of costs in a situation where there is no action they can take to avoid that risk, only weeks before the hearing, when there may be up to 3 leading counsel appearing on the other side. We submit simply
So really, it's
impossible.
at the initial point when deciding whether to fund at first instance that the Legal Services Commission should be reckoning on the possibility of succeeding and having to defend that success at some later point, either on a first or second subsequent appeal.
Well, it's not unforeseeable, is it?
No.
So exactly.
But that's the point,
Yes,
you say.
yes.
And therefore, I mean, I suppose there is a risk that, I don't know, they might then say to themselves, well, if this was going to go no further first instance, we would back it. But as there's a risk it might be going very much further, it's not worth the candle.
Well, my lord, it's not for me to speculate on that, but we submit what they cannot do is what they've done in this case.
Right.
So your lordships have my submission about the intolerable position in which E is placed, and that's a matter which is dealt with in more detail in Mr. Halford's witness statement, paragraphs 6 to 8, page 3 of this volume, where the very limited means, it's obvious that anybody who is entitled to support from the Legal Services Commission is going to have very limited means, but we make the point that the result could be catastrophic. There is one error in this witness statement, which is that it's suggested that E could be exposed to the costs in the Court of Appeal and the Supreme Court. That is not correct. If funding were withdrawn now, he would only be exposed to costs after the date of the withdrawal of funding. But nevertheless,
Paragraph 6.
that's paragraph 6. But so it would only be the costs after the withdrawal of funding. But nevertheless, likely to be a very substantial sum and far beyond anything that he would be able to pay. And in that situation, we felt we had no option but to make this application because of the position in which we have been placed. Mr. Halford then goes on in his witness statement. At paragraph 9, he addresses other interests and the significant wider public interest. And then at paragraphs 11 onwards, he explains the situation for legal aid firms if a situation is allowed to subsist where there is to be no order for cost either way in the Supreme Court, and explains the implications of that outcome for a firm such as Bindman's. And he says, frankly, at paragraph 20, he says, I can say unhesitatingly that despite this case being important, challenging, and wholly in line with the direction my practice has taken in recent years, public law cases with a discrimination element, I would have had to turn E away, as he was turned away from a number of other firms, had there been no prospects of recovering inter-party costs.
Yes.
That is also, simply for completeness, a problem that was recognised by Mr. Justice Scott Baker, as he then was, in a case called Boxall, which is in the authorities bundle at tab 9. This was a case which concerned the question of what provision for costs ought to be made if there was a late settlement of a judicial review application. And he was addressing a situation where a public authority receives pre-action protocol letter, doesn't respond to it, receives a claim for judicial review, doesn't respond to it, and then at a very late stage of the proceedings settles by effectively conceding the relief that was sought, but then seeks to avoid liability for costs. And it was being argued that there was no real need for there to be a costs order since the claimant was legally aided, so would be able to recover costs from the Legal Services Commission. And at paragraph 12, the judge said, quite apart from offending the statutory principle that legally aided litigants should not be treated differently from those who are not, the level of remuneration for the lawyers is different between a legal aid and an inter-parties determination of costs. That is said in part to reflect the risk lawyers take in backing a publicly funded case that turns out to be unsuccessful. And the quid pro quo of taking that risk, of course, is that if the case is successful, you should get the reward. Otherwise, the risk becomes unsustainable in the long term. It's all swings and no roundabouts. And Lord Panic, I believe, will be making the submission that this is the balance that, of course, is reflected in the statutory scheme.
Yes.
My Lords, finally, we do submit that it's very difficult to see how the decision that the Legal Services Commission has made is consistent with paragraphs in the funding code. I would like to wait and see how Mr. Hart explains that it is consistent before I develop that any further. So, my Lords, we apply for the order in the form indicated, but alternatively, we would be content for this court to follow the course proposed by Lord Panic, that it should make it clear that Legal Services Commission funding should continue on the usual basis in accordance with the statutory scheme. Unless I can be of further assistance, those are my submissions.
Thank you very much indeed. Lord Panic, you follow, do you?
Yeah, please, my Lord.
I'm not sure whether this is the start of a fresh innings or whether, I think you weren't quite able to complete your century in the House of Lords.
Well, the last
You
case
did?
in the House of Lords was the
Oh, I see, I've been misinformed. So you can...
One can't always believe what one reads in the papers. It was this case.
That was this
I
case.
see.
Yeah.
Yes.
We were able to congratulate you
Well,
on it, I
indeed you
believe.
were.
on
Most
that.
grateful I was. Thank
Yes,
you
so
very much.
you
This is number one.
Number one. Very well.
There are two matters I wish to address, Lords, my lady. First, as my friend Miss Rose has made clear, this application for a protective costs order only arises because of the decision of the LSC to withdraw funding unless conditions are met. And our case is that the decision of the LSC is unlawful. Miss Rose indicates she agrees with that submission. And we invite the court to determine that issue first and foremost. The second submission is that if the court rejects that analysis and a protective costs order is required, then we have some brief submissions on the terms of that order. So the first point is that the decision is an unlawful one. We say, in agreement with Miss Rose, that it is quite impossible to understand why it is now inappropriate to fund this case in the way that the LSC did so below. All that has changed is that as a result of the decision of the Appellate Committee on a stay, E has the right to go to the school this autumn. It is self-evident that the case remains of very considerable public importance. That, after all, is why 7 justices of this court are sitting to hear the appeal later this month. It is why the Secretary of State is seeking to intervene, and it is why also, at the level of this court, the Equality and Human Rights Commission have told us that they are seeking to intervene because they regard the case as raising fundamental questions about discrimination law that travel much wider than even the important implications for schools and for the generality of pupils, not just E, who may wish to go either to this school or to other religious schools. It is quite astonishing in our respectful submission that the LSC should suggest that there is any question whatsoever about the public importance of the appeal that is being brought. The LSC's position, with great respect to them, is quite incomprehensible, even on a commercial basis. If the appeal were to succeed, we would expect to overturn the costs orders in favour of the LSC in the lower courts, and we would expect to obtain our costs in the Court of Appeal. That, on any view, will cost the LSC very significant sums, so they have a commercial reason to do their utmost to protect the position. What the LSC suggests, and Miss Rose has shown the court the letter already, it's paragraph 3 of their letter at page 46, they say it is not unreasonable to expect JFS to pay to do so, that is, to overturn the decision of the Court of Appeal. But that, with respect, ignores the fact that the case has only reached this court by reason of public funding from the LSC. It is impossible to believe, given the lack of financial resources of E, that this case would have been brought in the first place without that public funding. It ignores the public interest in the litigation, which I've already mentioned. It also ignores the fact that if we were to succeed in the substantive appeal, an order for costs could only be made against the LSC if it were, quote, just and equitable that costs should be paid out of public funds. And I'm not inviting this court today to determine anything relevant to that. That's Regulation 5.3d. Plainly, we would say that it is, but I entirely accept that it would be open to the LSC, were we to succeed in the appeal, to say for whatever reason they wished that it was not appropriate that we should get our costs out of public funds.
Normally a decision of that kind is taken at the end of the case.
Precisely
One knows
so.
the full range of
Precisely
the argument.
so. Our complaint is that the way in which the LSC have approached this is effectively to deny this court on an appeal the opportunity to apply the legal aid system and for the court to make that decision rather than the LSC in its own favour in a case that self-evidently has the most considerable public interest. There is finally the factor that the suggestion that public funding will be withdrawn comes at the 11th hour. The position of the LSC is that they are prepared and are funding E for the purposes of all steps in this action, in this appeal, up to and including the filing of the printed case. So what we're talking about, as I understand it, is the costs of supporting E in preparing the oral argument and in attending the hearing. My Lord Brown asked my friend Miss Rose a few moments ago whether, if we were correct in this analysis, the LSC might be less willing, this was what I understood to be the question, might be less willing to fund cases at first instance because of the risk that cases may go further. Our answer to that is that, of course, most cases do not go further. They stop at the first level. The second point is that at the High Court level, the LSC is fully protected against the payment of costs because you can only get your costs if you're an individual who would suffer hardship. The third point is that the LSC can always decide whether to support on appeal a losing case, that is, a case that's been lost at High Court level. If the case is a winning case at High Court level, then the LSC would expect to have reasonably good prospects that the Court of Appeal would uphold that decision. And of course, the case can only go to the Court of Appeal with the leave of the court, and the court is perfectly entitled to consider what terms to impose on the granting of leave. So we say it is highly unlikely that a decision in our favour, Miss Rose's favour today, would have any implications whatsoever. And even if it would, it doesn't affect the illegality of the approach that's being adopted. If necessary, and I emphasise necessary, we say that it's not merely that the decision here is wholly unreasonable in a public law sense, it also would frustrate the statutory scheme. And the statutory scheme is designed to preserve a balance between the privately funded party on the other side and the party with the benefit of public funding. And the way in which the system does that is to prevent the other side from recovering its costs at first instance level, unless it's an individual who would suffer financial hardship. It protects public funds at appellate level because you can only get your costs if it would be just and equitable to do so. And the conditions which the court has seen that the LSC wishes to lay down would simply subvert the limited protection that the privately funded party does enjoy under the statutory scheme.
You're referring particularly to Regulation 5, are
Yes,
you, and the various heads
absolutely. That's where Parliament has decided, or rather the Minister, approved by Parliament, has decided what the balance should be between the competing interests. And what we're told in this case is that they, the LSC, will only grant legal aid if, and this is the page 45 letter, if we agree that the costs order made in the Court of Appeal should stand in any event. A bizarre condition, the idea that even if we were to succeed in the substantive appeal, we must still pay the costs in the Court of Appeal, and we must pay them in the High Court, and we must pay them, of course, as Ms Rose has already indicated, at normal rates, not at legal aid rates, at taxed rates. Now, that may well be a very substantial amount of money. Why on earth should it be consistent with the statutory scheme that such a condition be imposed?
Can I just fit the Corner House case into this?
Yes.
I mean, that basically was the order in Corner House, but of course that wasn't a legally aided case.
No, it wasn't.
But that was the order.
The order, what was said by the court, Miss Rose will remind me if I've got this wrong, that those were the terms on which leave to appeal was going to be granted.
Right.
And of course it is always open to the court to do justice as it sees fit. Yeah. Very often this court will be well aware of it. In granting leave to appeal to the old appellate committee, the Inland Revenue would be told, yes, you can have leave to appeal in a particular taxation matter. But because it's of great importance to you, you must agree not to seek costs from the individual who might be bankrupted by the appeal succeeding.
And you can't seek to disturb the costs order against you below either.
That may well be considered.
And that's basically a Corner House. But it wasn't a legally aided case.
It wasn't a legally aided case. Very different here, we say, because... What, I'm sorry? Yes, the Corner House was a conditional fee arrangement as well, Ms Rose reminds me. But here we do have public funding, we do have a statutory scheme, and we do have a background of public funding having been granted hitherto. That's the features, those are the features of this case. The second condition, we should agree an undertaking. There will be no costs order in the Supreme Court, with both sides bearing their own costs. Well, that's very unsatisfactory. Not so much for us, it's unsatisfactory for Miss Rose for the reasons that she has pointed out. So we say that this would not merely be unreasonable, this position, it is inconsistent with the statutory scheme. What then can this court do about it? Well, we have drawn attention, as my Lord the Deputy President has mentioned, to Section 40 of the Constitutional Reform Act 2005, which is at tab 2 of the...
Subsection 5.
Subsection 5, the court has a very broad power to determine any question necessary to be determined for the purposes of doing justice in an appeal to it under any enactment. One could not have a broader power. I say that those powers are wide enough for the court to decide today on conventional judicial review grounds that the LSC's decision to refuse funding unless these conditions are agreed is unlawful.
So you're suggesting we simply make a declaration to that effect?
Yes. Secondly, I say that the court should go further. It should say that the only lawful decision in the light of what has happened, in the light of any other factor being identified by the LSC as to why funding should not be granted, is a declaration that E is entitled to be funded in this court without conditions. Thirdly, I invite this court to decide that in the light of that, a protective costs order is unnecessary in this case. If the court were to think for some reason that it's not appropriate to make formal declarations, that it's appropriate simply to give a decision refusing a protective costs order for those reasons or analogous reasons, that I would respectfully submit would amply protect E, because it would be quite inconceivable that the LSC would then refuse to give public funding, and if they did, they would find themselves in the administrative court with paying costs to Miss Rose's clients on a judicial review claim that would be unanswerable.
Trouble is, we don't have a lot of time to play with,
No.
do we? I mean, the appeal is to be heard at the end of the
Indeed.
month, and we're caught in a position where I think everybody would recognise we need a contradictor.
I would respectfully agree.
I mean, on these issues are so important, we can't just, as it were, nod them through without a proper argument. And if DE disappears, then it doesn't look, from what we know about the interveners' positions, that they can substitute for E's position.
Certainly not. It would be most unsatisfactory from all points of view. I respectfully agree with Miss Rose. If this case were not properly argued on the side of E by those who are familiar with the issues.
Well, we of course, the fallback is an amicus, but then it doesn't really seem satisfactory with only 3 weeks or so to go.
I respectfully agree. It's no part of my submission that there is any alternative, any sensible alternative to funding to be provided. The question is whether it should be public funding or whether some other device, some other method should be arrived at.
Can you just help with this, Lord Panic? Remind me, I mean, on the 31st July,
Yes.
when we touched on this question of whether there might need to be an application for protective costs order, my recollection is that the context in which we did so was the possibility that E's earnings would reach a point where his certificate would be withdrawn on financial grounds.
Precisely so. Miss
But
Rose mentioned that possibility.
Nobody hinted for an instant that there would be any question of withdrawing them on any other grounds.
Because neither Miss Rose nor I contemplated for a moment that there could be any doubt whatsoever that the fact that E had the right to go to the school reduced to any appreciable extent the obvious public interest considerations that led to the original grant of legal aid and led to the appellate committee granting leave and this court deciding that it should be heard by 7 justices and the others seeking to intervene. It simply makes no sense.
So I mean, was this letter that we've looked at more than once of the 18th of September the first intimation, as far as you know, that...
Well, Miss Rose is in a better position than me. As far as I know, we saw nothing prior to that letter, I think it's right to say. And I make no complaint about that.
No,
but as
that's the
I
first
understand
union.
it, there had been earlier correspondence and discussions immediately before. It was very late in the day.
Well, there's a conversation, obviously, which led to the letter, but I mean, there's no reference to any prior...
Yes, there were emails, but days rather than weeks before. Yes, very, very soon prior to the 18th of September. My lords, my lady, Mr. Jaffe for the United Synagogue puts, if I may say so, the point very well in his written submissions for the United Synagogue at paragraph 5. He points out that a protective costs order is a very important means of promoting access to public law justice where public funding is not available. And he's right. But in the present case, as he points out, the effective beneficiary of any protective costs order would not be E. It would be the Legal Services Commission. And there is absolutely no reason whatsoever, as a matter of justice, in the light of the history of this matter and the continuing public interest, why this court should make a protective costs order in order to protect the position of the LSC. We understand entirely why Ms Rose has been compelled to make this application, but she recognises that, as we submit, the decision of the LSC is unlawful. It cannot, in our submission, be allowed to stand.
I mean, just pausing at that stage, I mean, it's not the first time that, in effect, such an order for the benefit of the LSE has been sought, because it was sought successfully in Weaver. I for my part, would accept that there are very significant differences between the cases. But, I mean, let us realise where we are. It isn't unique in that respect.
Well, let me emphasise then, I'm not asking this court to determine it would never be appropriate.
Right.
But plainly there are different considerations that apply in a case where the effective beneficiary of the application would be not E, but would be the Legal Services Commission. And one needs, I would respectfully submit, in such circumstances to look very carefully indeed, by reference to the previous funding, by reference to any changes that may have occurred in the facts, as to whether it really is appropriate to protect the position of the LSC. And of course, as Mr Oldham reminds me, there was no argument in Weaver as to whether the LSC were acting unlawfully. The point didn't arise, wasn't argued.
So a declaration would really be directed to the events which have happened
Yes.
in this case. Would that be right?
It would, my lord, because what's happened previously is uncontentious. The LSC did fund, they continue to fund. The only question is whether they should continue to fund, I emphasise, after the filing of the printed case. That's all we're concerned with. Now, my lords, my lady, I have further brief arguments that I need to raise if, contrary to those arguments, there does need to be a protective costs order. I'm in the hands of the court whether you want to hear me on that now or whether you would rather hear on the issue of principle first.
Argument first. What do you think?
I don't think it matters.
So perhaps we have them briefly now. And then
Yes,
we'll
might as
go.
well, yeah.
I think, Lord Panic, if you could just put the points briefly forward.
Very well.
If we have to return to them.
Very well. The first point is, even if there's a PCO, there is absolutely no reason why it should cover the costs below. That is in the Court of Appeal and in the High Court. The LSC did provide public funding. If the appeal succeeds, I say we're entitled to ask this court to remove the Court of Appeal order and to order that we should have our costs from the LSC in the court below. That's the first point. The second point is that...
In the Court of Appeal below, not at first instance.
No, but we would wish to overturn
Exactly.
the order that
No,
we
I follow
paid.
that. I follow
But no, we're not an individual who
Exactly.
suffered hardship, so we couldn't in any event obtain our costs in the High Court.
Yes. Yeah.
The second point is the costs in the Supreme Court. The position is this: Bindmans want an order that prevents us from claiming costs in the Supreme Court if we win, but an order that requires us to pay their costs on commercial rates if we lose. And they've explained why that is. Now, we say it is well established that when a protective costs order is made, the court will consider all the circumstances and it will cap the benefit to the poorer party. That's the party being benefited. And that's Cornerhouse at paragraph 76. And we would say if there is to be a protective costs order, then the amount we should have to pay the legal team for E should be capped at a modest figure if they win and the appeal is dismissed. And that's because, first of all, we're not going to get our costs if we win in the Supreme Court. Secondly, if Bindmans win, if E wins, they will recover a very substantial amount of costs in the Court of Appeal and the High Court, so they're not going to be out of pocket. They're going to get a lot of money, as they put it, on the standard cost basis. And the third point is that we are, of course, both us and the United Synagogue, charities. And if one looks at the cases, and I'm not going to take time on it, one sees from Corner House onwards that the amount of money has been capped at very modest figures. We're talking £10,000, £20,000 figures. And if one adds that to the amount that they will receive if they win in the Supreme Court from the costs order in the Court of Appeal and the High Court, they are certainly not, in this case, in a position that is going to lead to Bymans having to close their doors. That's simply unrealistic. Those are the points I'd want to make if we got to that stage of making a protective costs order. Unless there are other matters, that's what I wanted to say to the court. I'm very grateful.
Now,
I think
Mr.
Mr. Jaffe wanted
for you
to
to follow, I think, isn't it?
Want this?
My Lord, this is the kind of litigation that really gives lawyers a bad name. It's satellite litigation about legal costs, which is ancillary to an appeal, at least so far as the United Synagogue is concerned, which is obviously about much more important and interesting things, but about legal costs as well. The simple explanation of what is going on, which is central to understanding what in my submission is the proper outcome for this application, is to understand what the interests of the relevant parties are in this application. E's position is, of course, very simple. He's got very limited resources and he has very heavy family responsibilities. He can't afford to litigate this important appeal, but everyone has agreed that it's essential that his lawyers are here to ensure it's properly presented. So for very good reasons, he seeks to continue the public funding, which of course comes with cost protection attached, or failing that, he seeks a protective cost order of some sort. And of course, he retains a strong personal and of course a strong financial interest in the outcome of this litigation, not least because of the stayed county court discrimination claim. The position of E's lawyers is equally simple to understand. They're being paid at prescribed rates at the moment, which means I think about something in the region of £120 an hour, but they'd like to be paid, if they win, at inter-parties rates for the very good reasons that Mr. Halford identifies in his witness statement. So that's E. The Legal Services Commission, on the other hand, well, they're very happy to fund E's lawyers, and it appears they're also prepared to fund E's lawyers to attend and make representations to the Supreme Court. But they don't like the consequences which are prescribed in the regulations if he loses in the Supreme Court, which is that this court, at the end of the case, not at the beginning of the case, if it considers it to be just and equitable in all circumstances, can order the Legal Services Commission to pay some or all of the costs in the Supreme Court and in the Court of Appeal, but not at first instance. So they would like the court to immunise the Legal Services Commission against any risk of having to pay costs out of its funds, despite its earlier decisions to fund the litigation. Position of JFS, obviously an educational charity, money that's spent on this litigation. There's no magic pot it comes from teachers, books and so on. And the same for the United Synagogue, money that's spent on this litigation is money that's not spent on its charitable objects. So everyone's position in this application deserves at least some degree of sympathy. The issue is the balancing of these competing interests in all the circumstances. And unfortunately, it's a balancing exercise that can't be carried out at the end of the case. It has to be carried out now because the Legal Services Commission have brought these issues to a head. They have made the threat that unless a protective cost order is granted, they are minded to withdraw funding. So very briefly, and I hope not covering any points that Lord Panic has already made, can I just mention the statutory scheme and then turn to deal with, if this court does decide to make a protective cost order, what the terms of that order should be so far as the United Synagogue is concerned.
Yes.
The point in my submission of Regulation 5 is to balance the interests of the Legal Services Commission, which is of course spending public money, against the interests of those who litigate against publicly funded parties, who are also, of course, often also spending public money, or in this case, charitable funds. And the balance is one which is for the Lord Chancellor to strike. in the regulations between those competing interests. And the balance that's been struck by the regulations is that the non-funded party has to suffer, at least at first instance, unless they're an individual that will suffer hardship. After that, when it comes to appellate litigation, the court, not the Legal Services Commission, that discretion is given to the court, has a wide discretion to order costs if it's just and equitable. And the regulations provide a comprehensive code for the exercise of that discretion, which gives a list in the regulations of all the relevant factors which the court is invited to consider, including the resources of the non-funded parties, which is Regulation 5.6. And I obviously mention that because of the position of the United Synagogue. That is a factor for the court's consideration. Now, the other aspect of the legal services position in this case is that it has a very strong interest indeed.
Very strong word.
Very strong interest, my lord, in ensuring that the Court of Appeal's order for costs in this case is maintained. Because your lordships have heard from Miss Rose that if the Court of Appeal's cost order is maintained, E's lawyers are going to have to make an election. They can either recover costs from the Legal Services Commission, or they can elect to take the inter-parties costs. And here, I very much doubt that's going to be a particularly difficult decision if the Court of Appeal's costs order is maintained. They will elect to be paid by the appellants. And so in that case, there will be no call on the Legal Services Commission's funds to pay for E's lawyers. And that's the explanation for the initially bizarre position, it might be thought, as to why the Legal Services Commission are perfectly happy to fund representation by Miss Rose, Miss Mountfield and Mr Halford in the Supreme Court, but they're not prepared to take the risk of any cost order which is made against them. It's because there's a very large financial cash incentive for them in doing everything they can to ensure that the appeal fails and that E's lawyers don't make any claim on the funds of the Legal Services Commission at the end of the case. There's a direct financial interest for the Legal Services Commission in the appeals which are being brought by the United Synagogue and by JFS failing. It's financially significant and important to them. And that's why they're willing to fund lawyers to argue for this. But of course, they're not prepared to accept the burden provided for in the regulations of the appeal succeeding. And in my submission, that is plainly the mischief of regulation, that Regulation 5 was designed to guard against. That the Legal Services Commission, if they don't like the effect of the regulations, the obvious solution is to seek an amendment to the regulations proposing a different balance between the interests of the Legal Services Commission and other parties. But as it stands, the Legal Services Commission is, in my submission, actually just trying to have their cake and eat it. We can all sympathise with why they want to have their cake and eat it. They've got very limited funds, we understand that, but it doesn't necessarily mean that that's what the statutory scheme permits them to do. That's my first submission on the propriety of what the Legal Services Commission proposed here. The other matter, which I'll deal with again briefly, if I may, is what the terms should be of any protective costs order, if this court is minded to make one. The Court of Appeal have considered the issue of protective costs orders on an extraordinarily large number of occasions in the last 4 or 5 years. And it's my submission that the principles which the Court of Appeal eventually got to are sound. And what the Court of Appeal has said is that a protective costs order ultimately doesn't actually come for free, because it potentially has...
Doesn't do what?
Doesn't come for free, my lord. It potentially has an unfair effect on the other parties in the litigation. And that potentially unfair effect should be tempered in 2 ways. And the first way in which the court will seek to temper the potentially unfair effect of a protective costs order is by examining whether it is possible to require the beneficiary of the protective costs order to contribute something if they lose. So a protective costs order may not be absolute, it may be partial. And so in the Corner House case, which reached the appellate committee last year, at first instance, there was a different protective costs order from the one you've heard about today. The protective costs order that was made is that Corner House and Campaign Against the Arms Trade would have to pay the first £70,000 of the serious fraud officer's costs if they were to lose at first instance. And then having won at first instance, the divisional court made a different order as a condition of granting leave to the appellate committee. But that is the form of order which the Court of Appeal recommended and approved in Corner House, and which, if your lordships are minded to make a protective costs order today, it should be in that form. Your lordships and your ladyship should consider what the assets are of the party who is seeking the protection of the order, which is the Legal Services Commission, and tailor the order appropriately. The second way in which I submit that the effect of a protective costs order should be tempered is by capping the costs of the lawyers which are acting for E to ensure they're kept to a modest level. And again, in the first Corner House case, the Court of Appeal gave guidance as to how that exercise can be carried out. And the order which is commonly made in the Court of Appeal in first instance is simply to refer to that judgment and leave it up to the cost judge at the end of the case, which seems to work relatively well in practice.
You mean we don't have to try and do any sums ourselves?
I'm very much hoping that your ladyship doesn't have to engage in a prospective cost capping exercise.
Well, I believe you hope we don't have to make the order at all, but supposing that we do.
If you do have to make the order, it's my submission, it's unnecessary to engage in a cost capping exercise. The appropriate order is the one which the Court of Appeal made in Corner House, and which can be dealt with at the end of the case with a cost judge setting an appropriately modest level of costs.
Can you just explain what that order was? It's simply to remit to the cost judge to consider capping.
What the cost judge was asked to do in Corner House was to cap immediately because there was plenty of time available. What has happened in subsequent cases is the cost judge has dealt with the issue at the end of the case and has imposed a cap when assessing costs, which is, in reality, has turned out to be somewhere between inter-parties costs at an ordinary commercial rate and Legal Services Commission prescribed rates. It's not as high as inter-parties costs, but it's not as low as prescribed rates. And argument has been heard before cost judges as to what an appropriately modest level of fees is, and in very rough terms, that tends to be how it's come out. It's a compromise position. Yeah. And that is the compromise which the Court of Appeal said in the first Corner House case was the appropriate price for obtaining a protective costs order.
This is the order at paragraph 147 of...
That's correct, Alex.
Yes.
The final point which I wanted to make was in relation to the costs order which was made in the Court of Appeal. Now, as I understand the application is that the costs order made in the Court of Appeal should stand in any event, and Lord Panic has made general submissions about that. So far as the United Synagogue is concerned, if that order was made, it would make the costs appeal, which the United Synagogue is bringing at the end of this month, completely pointless. So I would hope that your lordships would not be willing to make that order now. It might be an order which is better made having heard argument on the substantive appeal. Unless I can assist your lordships and your ladyship any further, those are my submissions.
Thank you very much indeed. Yes, Mr. Hart.
Maybe I'll start by locking horns with the unlawfulness point.
Yes, please.
Recognising immediately that this court is anxious to have a result as soon as possible, given the appeal forthcoming, and also recognising on behalf of the Legal Services Commission that there simply isn't time for any sort of long drawn-out judicial review or anything of that sort.
Yes.
Well, it would help me, Mr. Hart, to have at a very early stage an indication of what actually are the conditions that are the preconditions to your continuing readiness to grant the certificate.
Well, Lord,
By reference to this letter of the 18th of September.
Well, I was going to add at the beginning of my submissions that Mr. Reddin made it clear in his witness statement, which post-dated that letter, that it was only a minded-to letter. He still hasn't finally decided his position, but I'm about to indicate to the court in effect what his position would be, and it's this. He would accept that if this court made a protective costs order in respect of the costs in the Supreme Court going forward.
Yes.
On the basis of that E does not have to pay that E does not have to pay the costs of this appeal. On that basis,
That E doesn't have to pay the cost of the appeal?
yes, and therefore the Legal Service Commission would not have to foot the bill in any event in respect of any cost liability.
Yeah.
It's plainly a matter for the court whether, if the court were inclined to make a protective costs order, it should make it in the form which I have indicated or in the form which was sought by Ms. Rose. And on behalf of the Legal Services Commission, I don't make submissions as between that choice. But as far as the Legal Services Commission is concerned, that is the matter which gives him concern if he is not provided with immunity against the costs going forward of this appeal.
Well, can I just see where that takes us to, just to try to clarify the issue? Looking backwards, if I may.
Yes.
You're not now, am I right? You're not,
That's right.
You're not contending that you should be protected against a reversal of the order for costs made in the Court of Appeal?
On reflection, having heard the arguments put in this court and also having seen Mr. Redding, having seen rather more of the history of the matter of which he was not aware until the last few days, that's accepted.
So as far as the Synagogue's position is concerned, again, if they were successful, you would accept it. The ground is open for them to contend that the 20% finding should be reversed against them.
Yes.
And what about the costs of that argument in the Supreme Court? Because this is a distinct issue which doesn't really, as I understand it, doesn't get into the merits of the other issue. Would you be prepared to accept that so far as attributable to that issue, the costs of that would not be covered by PCO?
I would accept that, yes. And again, if I can indicate, we were considerably helped by Mr. Jaffe's note for this hearing to identify precisely the basis upon of their involvement in the case as intervener and appellant. That has helped our understanding of where matters are.
So you don't seek any
yes.
order at all in respect of United Synagogue costs?
Yes.
Either below or on appeal?
Yes. Which brings us back to Lord Panic's point of principle, the statutory scheme and the like.
You know, you started with an if, and you never finished the sentence. You didn't actually say what the consequences would be if this court did or did not make the protective costs order that you want.
If the court made a costs order along those lines, funding would be extended.
And if we didn't?
Funding wouldn't be extended.
I thought you should be put on the spot
to
say what your position is.
And that's a decision now, is it? That's your position. It's not a minded to position.
It's a decision, yes. Well, I put it that way because, in a sense, there is, given the time, there's no real alternative other than to articulating our position in that way.
And can I just be asked you, so when you say it's a matter for the courts, the form of this order in respect of the Supreme Court, does that mean either it should be that E doesn't have to pay the costs of the appeal even if he loses it, but he should be entitled to claim the costs of the appeal if he succeeds in resisting it, which is, I suppose, Miss Rose's preferred view, or the drop hands, which is enough for your purpose, but plainly not for the lawyer's purpose.
That's right. That's why we say that in a sense that's not an area where we would make submissions. Either would be satisfied, either because they would meet the particular problem which we face, which is the future liability for costs.
Yes.
Has the Legal Services Commission ever taken this view before, when a publicly funded person who succeeded in the Court of Appeal is having to respond to an appeal to, of course, this court hasn't existed before, but you know what I mean, our predecessor. Is this a position the Legal Services Commission has, to your knowledge, ever taken before?
No.
So our first case is a test case indeed.
I mean, that's right, is it? What
What about Weaver?
What about Weaver?
Well, I was saying to this court.
To this court.
Oh, to this court,
Yes.
yes.
Yes. Sorry, I beg your
Yes,
pardon.
I'm sorry.
I took
I'm being a little bit
in that
grand,
way. Yes.
but cases that come to this court are of special importance.
Yes.
They don't come otherwise.
No.
And you've never done it before.
No.
Yeah.
But in a sense, the interrelationship between the PCO jurisdiction and the Legal Services Commission's involvement. The PCO jurisdiction is a relatively recent one, and there are only going to be a relatively few number of cases that come before this court where the question might arise.
Why? Why relatively few cases?
To date, I mean, they did.
Yes, but from now on, we have lots of cases in which there are legally aided. That's the wrong term. Forgive my being out of date. Parties are responding.
I think your point was really that it's a product of the time that has intervened between the beginning of this kind of jurisprudence and where we are today.
Exactly.
I mean, looking forward, I think you wouldn't dispute that there is a developing area here. I mean, the very fact you're here is demonstrating that point, isn't it?
Yes, I was answering Lady's question, answering her question simply as a matter of history, without indicating that.
Yes, but for the future, will the Legal Services Commission be looking to take exactly the same line every time somebody they fund wins in the Court of Appeal and the other side thinks, well, this is an important point and we don't like it, and gets leave to come to this court?
There is a difference in this case, Lady, without getting down to the facts of this case, which is that E succeeded in his principal aim in the litigation, which was to get his son into school.
But forgive me, Mr. Hart,
Yes.
that is true in a lot of our cases, because in the immigration cases, very frequently, the situation is that the person concerned has actually been given some sort of leave to remain in this country by the time the point gets to this court. And so that person often isn't there. I believe that Em's father is here today, and he retains an interest in the case. But we have many cases in which the respondent, who has been publicly funded, has actually no interest. And we continue to hear them because they're important.
But that question is indeed relevant to the question of whether funding should be granted in any given case. I will take the court to some of the few parts of the guidance which bear on that question in my submissions in order to make this point, which is...
I mean, would your position be different if we hadn't lifted the stay? I mean, say the timetable had enabled this issue to be resolved, before it had been before the question as whether the child could go to the school this term had arisen. So there was a stay, and it all remained to be decided. I mean, would your position be different? It's just the accident, is it, that the time has pressed and the boy's gone to the school? Is that a material factor in the case?
Yes, it is, because that's the objective, was the objective of the litigation. The objective of the litigation was to secure that admission. And it's coupled that with the agreement of the school not to disturb things thereafter.
Well, that's for this child, but I mean, assume that because it's not, you're no longer funding it, the appeal succeeds when otherwise it wouldn't. Next year there'll be another parent of a child affected, and that child will want to bring the case, no doubt, the same case. That way you would then be prepared to fund it.
Well, in each case, we would have to look at the collection of factors at that point. What were the likely costs going to be of that particular set of proceedings? What were the likely benefits of those proceedings? And reach the sort of decision on funding that officers of the Legal Services Commission reach every day.
But you do accept, don't you, that when appellate courts consider whether or not leave should be given to appeal, they consider whether the appeal has broader significance, particularly as it rises up to our level.
Yes.
So by funding the appeal to the Court of Appeal,
yes,
don't you accept that you were opening the possibility, at least, that you might be taken to a higher level if you were successful in the Court of Appeal? And it would be because the case raised issues of general importance.
That's right. And the little bits of funding funding guidance and code which I hope to show the court simply indicate that even that where there is a significant wider public interest, it is still a matter for the LSC to decide in a given case whether it is reasonable or unreasonable to continue to fund. So that even where there are all these things which plainly this court and the other advocates attach a great deal of importance to, the LSC still have to reach that decision, taking into account taking into account the benefit to the party himself, and taking into account future costs, both paid out on the lawyers funded by the fund, and also in respect of the liabilities of the fund. So, significant wider public interest doesn't just win the day without any more. That's my submission in a line.
Well, where do we go from here? Are you going to take us to the regulations to show what what guidance, if any, they give us?
Absolutely. And my preliminary submission to that was that when learned friends have been talking about the statutory scheme includes the code.
Yes.
And taking your Lordship very quickly to the authorities bundle to tab 1, where we have 2 sections of the Access to Justice Act. We can see from the first page of it, section 8, Code about provision of funded services. Sub 1, Commission shall prepare a code. And then really just glancing down sub 2, the sorts of things that have to be, the criteria that have to be set out in the code and the considerations to be taken into account.
Yes.
And so whenever one talks about the funding code or funding criteria, one is talking about a document prepared under instruction under that Act. So the statutory scheme includes that. Now to the key bits of the funding code itself. First of all, tab 4. And we're moving here to Part A of the funding code, where there are some criteria which are a short summary of the position on given topics, which is then expanded in the guidance to which I'll come in a moment. But if one looks at 7.5, post-permission criteria, this is in the section concerned with judicial review. And at 7.5.2, the presumption of funding, if the case has a significant wider public interest, is of overwhelming importance to the client, or raises significant human rights issues, then provided the standard criteria in Section 4 and Sections 5 are satisfied, and we can ignore those words for present purposes, funding shall be granted, save where in the light of information which was not before the court at the permission stage, or has subsequently come to light, it appears unreasonable for legal representation to be granted. Now, the information in this case, which emerged since permission was granted, it is the effect of the ruling of the House of Lords, namely, that, yes, exactly, that M was admitted to the school, and further the school's agreement that was irreversible. So, in a case where there is significant wider public interest, where the Commission reach a view as to future private benefit to the funded party, the Commission may reflect that and consider whether or not it is reasonable or unreasonable for there to be legal representation. And
as I understand it, you think it is reasonable for there to be legal representation. All you don't want is the consequences which flow from that.
We consider it to be reasonable for there to be legal representation if that is at a cost which does not exceed the cost of representation itself. What we do have to take into account is the effect of making an unlimited order of representation, where that comes at the potential cost of losing in this, of the funded person losing in this court.
Where do we find in 7.5.2 that that's a factor that's proper to be taken into account?
Not expressly set out there, but there is a completely general indication there in the words, it appears unreasonable. Again, this is a matter for the Commission to decide. Can I now take you to one other part of the funding code, which concerns withdrawal of legal aid. And at this point, I must ask whether the court has before it a bundle of parts of the code which was sent by the Legal Services Commission earlier this week.
I rather doubt it.
If you don't, we have the relevant page, and so we can hand up simply the relevant couple of pages.
I don't know.
It was about a 30 or 40 page clip of
I
documentation.
mean, was it attached to Mr. Reddin's?
We had this purple folio, it's got, and then it says Part A.
Code criteria. Is that any good?
Yes, that would be it.
Well, this is in the purple thing after
Thank
Reddin.
you.
Oh, I see. Oh, yes, I think we do. Yes, something anyway.
So Part A, the funding.
And 7, from which we were looking just a moment ago, was taken from that. But I want to take you, if I may, to 15,
Yes.
which is at page 36-2.
Oh, no. Oh, Oh, yes.
withdrawal of funding. Now, one could have a quibble about whether this was withdrawal of funding or simply failure to extend, but we say that the principle should apply. And at 15.3, one has reasonableness. Funding may be withdrawn where it's unreasonable for funding to continue in all the circumstances of the case, taking into account the interests of the client, any wider public interest, and the interest of the Community Legal Service Fund. So that is the summary of the criteria, and then that is duly expanded in the guidance. And if your Lordship, if the court then, forgive me, goes to tab 5 of the red bundle, you will find a heading 13.7, claims not subject to cost-benefit ratios, and so we're one of those. And what follows is guidance which assists the LSC to decide when to discharge certificates. And we can see from 13.7.1 at C that it applies to certificates for full representation or litigation support in proceedings which have a significant wider public interest. And then we see discussion as to circumstances in which discharge might arise in the more typical cases considered by the Commission. And then at 3, on the next page, if when prospects of success and cost-benefit criteria are applied to the certificate interpreted the way described above, those criteria are satisfied, funding will continue and the certificate will not be discharged. If those criteria are not satisfied, the certificate will normally be discharged, but a Commission will have a discretion to continue funding. Now, just pausing there and before just looking at the nature of that discretion, in a typical case where the legally funded party has got the benefit of the litigation, of what he sought in the litigation, the LSC will often discharge the certificate because there is no point in continuing to litigate. And so on a typical basis, one would be looking in those circumstances. One would be looking in those circumstances a decision where the criteria were not satisfied. So one then has to look at the nature of that discretion. And the two passages I take the court to, A and E, A referred to by Mr. Jaffe in his note. Funding will be continued if there is a significant wider public interest. In doing so, for interest in a public interest case which is seeking to establish an important point of law, it may be in exceptional cases, I stress those words, be appropriate for funding to continue to trial till the point of law is finally established, even if it appears at a late stage in the case that the prospect of establishing the legal issue in the proceedings is low. Sometimes benefit comes as much from clarifying the law as from establishing a particular proposition. And then going to E, ignoring for present purposes, the relevant B, C and D, otherwise the issue for the Commission is whether it's in the interest of the Community Legal Service Fund for funding to continue. The certificate should be funded if it's in the fund's interest so to do. Discharged, it is not. And then there is an example where the fund is considered whether to support a matter simply by continuing hereon in order to obtain its costs or not. But Lords, I take you to the last 3 or 4
Sorry,
lines.
can I just be clear? I mean,
Yes.
E, when it talks about the interests of the fund, are those always and exclusively going to be costs interests? In other words,
Yes.
the chances of getting the money out of the other side?
Yes.
Yeah.
and also the last 4 lines, and this is what I particularly attach onto, the last 4 lines of E, where the interests of the funds are considered, the risk, if any, of a cost order under Reg 5 must also be taken into account.
That's against the fund.
So, exactly. So the benefits, on the one hand, of the LSC pursuing the litigation and also the detriment of it pursuing the litigation are both to be taken into account under E. And I remind the court that this guidance is applicable to cases which have significant wider public interest. That's one of the categories under 1C that we looked at when I took you to this document. So what the Commission says is that whether one is looking at it through the prism of 7.5.2, applicable to judicial review with a significant public wider interest, or through this particular guidance concerning the withdrawal of certificates in cases of significant wider public interest, it is open to the Commission to consider the possible liabilities it may suffer under a Regulation 5 order. So we say that is the short answer to Lord Panic's point, because it is part of the statutory scheme that the Commission will do so, may do so, exercising its powers under that self-same scheme and the code made under it. So it's not, one cannot, as he would seek to do, separate the code and the rules under which these sorts of decisions are made by the LSC on the one hand, and the Regulation 5 system on the other. They're all set down in the same act. So we say it is permissible to have regard to future costs, and it is permissible in this case to have regard to the fact that the major objective of this litigation has been achieved for E.
Is there anything in the code which, so to speak, explicitly directs itself towards the position when you are, when you've won below and it's a question of holding on to it?
No. Now that is our essential position underlying what Mr. Reddin says in his witness statement about his position. Various points have been made about various elements of his reasoning in the letter of the 18th of September, but in my submission, that's not essentially the point. The point is, could the LSC come up with a lawful decision with the effect of the one that I have indicated at the beginning of my address? And my submission is yes, it could.
And in assessing the reasonableness in a public law sense of this decision, I mean, it would be right, would it, to take into account the point in the litigation at which it is, which this order is sought, the protective cost order is sought?
Yes.
And indeed, when it was, so to speak, first bruited on this basis, yes?
Yeah. Yes,
I mean, given that we looked at the matter at the end of July, when this wasn't even a cloud on the horizon.
Nor at that stage, of course, the stay hadn't been lifted. The boy hadn't been admitted to the school.
True.
Which does very significantly change the complexion of much litigation, though I readily accept that that doesn't mean that all litigation goes for that reason, because it may still live because it has significant wider public interest.
Have we got a copy of the orders made in the Court of Appeal?
Yeah.
Yes. I think it's appended to Lord Panic's notes at his tab 2.
Yes.
Question didn't, of course, rise at that stage because they refused permission. So, that could have been the end of it.
No.
Yeah,
But, I mean, it was never thought appropriate when the petition for leave was made to the House to try and put the any grant on terms. It wasn't suggested that it would be appropriate to grant leave to the JFS to appeal, but only on the sort of basis which you now wish the appeal to go ahead on.
I wasn't there, but I'm told from my left that there was. I don't know whether it emerged from the Legal Services Commission, but I understand there was perhaps Miss Rose can help that.
Yes, my Lord, we applied to the Court of Appeal saying that we opposed the application for leave to appeal, but that if leave to appeal were to be granted, we did ask for it to be granted on terms including a protective costs order. But in the event, permission was refused by the Court of Appeal.
Right, but when it came to the House?
Well, unfortunately, we had no opportunity. Your Lordship will remember that it came right at in the dog days of the Appellate Committee, and we were deprived of the opportunity to respond. We would have made that application had we had the opportunity to do so. Yes, we did make it orally on the 31st of July. Yeah.
And we said wait and see, didn't we?
Yes.
Yeah.
But the only basis on which we had thought there was a risk at that time was on the basis of E ceasing to satisfy the means. We had no idea that this might be an issue.
Yes, of course. Yeah.
Was it technically, were we lifting the stay or declining to continue it?
Declining to continue.
That's what I thought.
Yes.
That's why I wanted to look at the order. I wanted to remind myself. The stay is in paragraph 12 of the order, and it stays the material paragraph, which is paragraph 7, for 14 days, and thereafter, if within that time a petition for leave to appeal is lodged until the determination of the petition. So it was only a stay until the determination of the petition. Yes. We determined the petition, so the stay then went. Now, the Legal Services Commission can read an order as well as I can. We were declining to grant a stay.
That's correct.
But thereafter, and I don't have the precise date at hand, I'm sure I can be provided with that, it would not be until we, the Legal Services Commission, were provided with information which suggested that the school had accepted that that decision was irreversible, that, in a sense, the lack of benefit, future benefit for the proceedings specific to E&M arose. So it's really only at that stage when we learn of that, and I don't have the precise date to hand as to when that was. It's really only at that point, and when the application is made on the 8th of September to extend legal aid to this court, that really the matter arose. So it's not been that great length of time, in fact.
Well, where do we go from here? We've looked at the code, and
yes.
Is there anything more we get out of that, or have we exhausted that?
No, we've exhausted that.
Yes.
And as I indicated, our position is that it is a perfectly lawful decision for the LSC to reach, given the considerations which I have indicated to the court.
Yes.
Now, if that be the case, then we say that it is an appropriate case for a protective costs order on the rather more limited basis which I outlined when I rose.
Yeah.
And those I've set out in my note, and the principles I think are fairly non-controversial. We would say in that instance it is an appropriate. It would be an appropriate case for this court to make such an order to reflect that, the effect of which would be to restore representation for E, and with the consequences of a PCO of whichever form the court felt more appropriate.
Yeah.
One which, so to speak, shares the punishment between E's lawyers and of the school on the hypothesis that they were to succeed.
Yes.
The other of which puts the whole of the punishment on the school.
One or the other, yes. We don't consider it's really for us to plump for one or the other.
Well, is that as far as we go with you? Yes. I think it probably is.
Unless I can help the court any further with.
Yes. Then you. Thank you very much. Miss Rose.
My Lord, Mr. Hart showed the court some provisions in the guidance that applies to the funding code, but with respect to him did not show the court what we submit is a very relevant paragraph. If you go back to tab 5 in the red bundle, paragraph 13.7, which we were just looking at. Yeah. He showed the court A and E, but did not show the court D. If proceedings are at a late stage, the client's Article 6 rights must be considered. See section 13.5 above. Now we have copies of section 13.5. I can just hand those up. If the court turns to the second page that we have here, which is the end of 13.5.
But we're talking now about discharging on the merits, not on income grounds.
Yes.
Yes, all right. Yes.
Not on the merits, 13.5. Yeah. If we go to 3, the importance of a case to the client must always be considered in decisions to discharge, especially if discharge is being considered at a very late stage in the proceedings. The client's rights under ECHR Article 6 must be considered in such circumstances. For example, it would not be appropriate to discharge a certificate on cost-benefit grounds alone if A, the case was approaching trial, B, it would be impossible for the client to have effective access if proceeding in person, taking into account the level of representation and funding of the client's opponent, C, the prospects of success of the case were better than 50%, and D, there'd been no significant change of circumstances since funding was last approved. Now, we recognise that the fund seeks to argue that the grant of the stay, or rather the refusal to extend the stay by the House of Lords, was the significant change of circumstance. But in my submission, it's clear, and certainly clear after Mr. Hart's submissions, where he did not even draw the court's attention to this paragraph, that the impact of this decision on the Article 6 rights of E has simply been ignored.
There is a flavour of first instance about that paragraph, isn't there, though? I mean, we're talking about cases approaching trial. It doesn't actually direct attention to appeal.
Well, but, my Lord,
is it a fortiori in the case of an appeal?
We say a fortiori because this is a withdrawal of funding in the 59th minute of the 11th hour in a situation where it is quite obvious that E cannot conduct this appeal without representation. There's nothing more I need to say about that. And we submit that there is plainly a breach of Article 6. And you heard the submission I made in opening about the impact on E if funding is withdrawn, where he faces a risk of cost in the Supreme Court that he can do nothing to avoid. And that is a point that the Legal Services Commission has simply refused to address at all, even though we put it to them in correspondence and we put it also in our application. And I made the point again orally today, simply ignored by the Commission. And we submit on that basis alone, this decision fails the public law test of rationality, because there has been a failure to take into account a relevant consideration, and moreover, a consideration made relevant by Article 6 of the Convention.
The paragraph 13.7 also has a first instance flavour to it.
Yes, my Lord.
It's much more about ordinary cases which start and then it looks as though they've settled, or it looks as though most of what was wanted means that the cost benefit.
We would submit that that's not surprising, because it's simply not contemplated in this code that having supported a person who has succeeded on appeal, the plug would then be pulled immediately before the hearing before the Supreme Court. Simply isn't contemplated.
Well, they don't want to pull the plug.
No, well,
they accept that
of course,
legal representation is necessary. The point, I'm afraid, I put to Mr. Hart, but they just want to provide it on terms.
And Lady, we respectfully agree and adopt that point, that it fails that condition in the code for that reason, that they're not saying that legal representation is inappropriate, they just don't want to face the consequences of granting legal representation. The test, of course, is that they must show that it is unreasonable for legal representation to be granted. And it's plain that there is no rational basis on which they could reach that conclusion, and therefore no lawful basis on which funding could be withdrawn in this case. The final point I want to make is about the terms of the protective costs order, if one is to be made.
Yes, well, things have been simplified quite a bit, and
yes.
We're down on the crux issue now. I think the side issues have gone.
Yes, the only question is whether there should be a reciprocal cap
Yes.
in the event that a protective costs order is granted. In my submission, that demonstrates the inappropriateness of the protective costs order model in these circumstances, because normally what happens in an application for a PCO is that a PCO is made for the benefit of the impoverished litigant who cannot otherwise get access to justice. And as the quid pro quo for getting that benefit, they are only permitted a modest amount of money to pay their legal team. But in this case, we gain no benefit from the PCO at all. The benefit goes to the Legal Services Commission, which has extensive resources. But we then suffer the disbenefit, namely the limitation on our legal costs, even if we win. And so we submit that it can't be regarded as an application of the principles that the Court of Appeal has developed in relation to PCOs, because the starting point that this is an order intended to afford access to justice to an impecunious litigant and for the benefit of the impecunious litigant simply has no application here. What is the Legal Services Commission is seeking simply to avoid any risk itself, and for that risk either to be borne wholly by the school or to be shared between the school and the respondent. And we submit that is inappropriate and unlawful.
Thank you very much. Well, we would like to take time to consider our position. What we propose to do is to withdraw for a while. If parties would remain in touch, we'd come back and give our decision in as short a time as possible.
Probably not, no.
Say something.